Can I please invite the panelists and the speakers of the first panel to join us? Thank you.
Good morning, everyone. My name is Haydee Dijkstal. I am a barrister at 33 Bedford Road Chambers here in London. I'm also counsel instructed by the International Centre of Justice for Palestinians, ICJP. And I have the pleasure today of being the chair for this panel and to hear our eminent speakers discuss genocide and international law. So the aim of the panel today is to speak about what genocide means under the law and the implications of the law as well. It's not to speak about genocide in Gaza and the word genocide as a mere descriptor or as an adjective of rhetoric, but to speak about genocide as it's reflected in the law under a legal definition and with a legal process for justice, accountability, and also for prevention and deterrence. It is through the lens of the law on genocide that the realities of the situation under which Palestinians live and under which they are injured and killed, that their experiences can be starkly crystallized and understood. International law and the rules-based order was created not only to put a positive obligation on states to protect civilians against violations and abuses, but also to provide mechanisms for accountability, responsibility, knowing the truth, and seeking reparations as well. But of late, the reverence towards international law has come into question, as has its ability to truly protect and provide recourse for all victims. So it's with that that I welcome our esteemed panelists today and look forward to the discussion. I'd like to first introduce Professor Richard Falk, who will be our first speaker today. Professor Falk is an Albert G. Milband Professor Emeritus of International Law at Princeton University and Research Fellow, Orphalia Center of Global and International Studies, University of California, Santa Barbara, and he is Euro-Mediterranean Human Rights Monitor's Chairman of the Board of Trustees. Professor Falk is a renowned international law and international relations scholar who's completed a 6-year term of UN Special Rapporteur on human rights in occupied Palestine. He's the author and co-author of over 20 books, plus countless edited volumes and articles on the subjects of human rights, international law, and global institutions. So I welcome you, Professor Falk, and please, you have the floor. Use this one.
Dear friends and fellow activists committed to the liberation of Palestine, it's a challenging honor to be here on this outstanding program, and I thank our chairwoman for her gracious words of introduction, and I thank the conveners for bringing us all together at this critical time in the Palestinian struggle. It's a historic moment, I think, poised between this genocidal ordeal that the Gazans have experienced most directly, and some sequel that promises to challenge the forces, the benevolent forces of society throughout the world, to stop the continuation of what was properly called the Nakba process, and to reverse that expectation by bringing to bear the interests of justice and liberation. The subject matter of international law is always problematic if approached from a progressive perspective, because the law has been used as an instrument of oppression and exploitation. And only recently, in the course of the anti-colonial struggles and to some extent the experience of World War II, has international law generated a counter-discourse that is associated with the pursuit of justice, where its historical role was primarily the implementation of the interests of the powerful. And so what my concerns ever since the Vietnam War have been to align international law with this progressive potential of challenging and transcending a world of exploitation and domination that has exploited the global South generally and all people, many peoples who are vulnerable to varying degrees. So in one sense, the appeal to law in the circumstances of the Palestinian struggle is a major way of challenging the continued geopolitical manipulation of law by those countries that won World War II and continue to have an exemption from accountability through the veto in the UN Security Council and through impunity when it comes to accountability for the commission of crimes. And we should remember that the winners in World War II held very publicized war crimes trials in Nuremberg and Tokyo, but only the crimes of the losers were investigated. So we are, in one sense, struggling against a world order system that was shaped back in 1945 by the winners of World War II and reflected their continued strategic ambitions to dominate the former, what became the former colonial world of the global South. And it's against that background that I think we have to appraise both the failures and the success of international law in the context of the Palestinian struggle. And to begin with, the failures are very much emphasized by the global media and by public opinion as both because the sponsors of Israel's behavior have tended to say there is no legal merit in recourse to international law, and therefore somehow accepting a view of the events that's contrary to what the spectacle of daily atrocities that the eyes and the ears of the world have experienced. The American Secretary of State, Blinken, in the Biden period, talked of a rules-governed world. He really meant a ruler-governed world. And it was an expression that didn't invoke international law because the US and its Western allies didn't want to be held accountable for its behavior within the scope of what had been agreed upon and reflected in the UN Charter, basically to appease public opinion at the end of a very destructive period in international history. It was never taken seriously as the design of the UN and the international law kept the pre-war structure of geopolitical primacy when it came to global security and war prevention. So one had these two opposing traditions at work. The correct perception of why even progressive people have been led to say, what use is international law if Israel can violate it so flagrantly and so cruelly and yet not suffer adverse consequences and enjoy the backing of these liberal democracies that present themselves to the world as the custodians of decency and human rights and so on. So the fact that you had, on the one hand, authoritative decisions by both the International Court of Justice and the International Criminal Court that backed the popular people's awareness that criminality on a vast scale was taking place, there was no way to implement those findings so long as Israel enjoyed geopolitical backing by the US and the other main Western powers. So it was quite natural to say it's useless to prevail legally if the decisions are not enforced. So the first thing to, I think, understand is what I call the implementation or enforcement gap that interferes with making progressive readings of international law affect behavior directly. In addition to the enforcement gap, there is also the complicity gap, that those that support this kind of gross criminality in the form of genocide are basically ensured of their impunity because there isn't the political traction to bring law to bear on their behavior. So the United States, despite funding and providing so much weaponry, is actually in a position to present itself as part of the solution. It's able to escape its criminality and to behave as if it's a mediating force. And that's been a poisonous element in the Palestinian effort to make use of international diplomacy. They never should have accepted the US as an intermediary in the Oslo diplomacy, because to accept that kind of partisan mediation is basically to politically surrender. And that's very negative kind of betrayal of the struggle. So in addition to this complicity gap, there's finally the accountability gap, in which those that perpetrate these crimes, even though the International Criminal Court issued, after much delay and political maneuvering, arrest warrants for Netanyahu and the former Minister of Defense, Gallant, there is no realistic prospect that they will be enforced in any way or implemented in any way. So those that commit these crimes, unless they're geopolitical losers, have no fear of being held accountable. Having said all this about the limitations of even the progressive dimensions of international law, let me also say a few words about why, despite all this, international law is extremely valuable, and it matters that the ICJ and ICC have sided with a Palestinian interpretation of these events and essentially rejected what Israel has been claiming with the Western support. It's valuable because it legitimates the struggle of people, which is the force of history that has emerged since World War II to undermine the traditional idea that the side in conflicts or struggles that has the superior hard power or military power will politically prevail. The famous adage of the Pope when he said that history is made by the side which has the superior armed forces, the better military capability. The Vietnam War is very paradigmatic for this period because it showed that a people that is mobilized and has the high moral ground and legal ground prevails over a military opponent or adversary that dominated the battlefield. And that was true in all of the subsequent colonial struggles of any significance, that they were politically controlled in the end, after much destruction, by the side with the high moral and political ground. And that, if one thinks of the Palestinian struggle through the lens of settler colonialism, it is important that international law has helped the Palestinians to be winning that legitimacy war. And to date, in almost all important cases, the winners of the legitimacy war politically prevail. And international law, through this legitimating role, justifies the BDS campaign, and it gives added stimulus to a more militant form of civil disobedience of various ways of doing what governments and international institutions should be doing, but have failed to do. It gives the peoples of the world, through civil society, both the responsibility and the opportunity to allow this struggle, which was enhanced in the South African case by just these kinds of instruments of soft power. And it is for that reason that international law is vital in countering the way in which the public order of governments and institutions fails to uphold a moral foundation for human behavior. And so let me conclude by saying that I think that these developments of demonstrating that the International Court of Justice and the International Criminal Court can be motivated to engage in just interpretations of the law that promote justice, and that's a vital step in transforming the system of public order. And I end with my hope and prayers for the liberation of Palestine and by the role of popular movements throughout the world acting in solidarity with that struggle that is the moral test that is being posed to all of us at this time. Thank you very much.
Well, thank you very much, Professor Falk. I think your words are incredibly powerful to start this conversation on the law and the law of genocide, and especially about how power and politics impacts the law, but still how the law is valuable and vital to ensuring morality in power and politics as well. So I'm now going to turn to Dr. Nimer Sultany as our next speaker, who's going to be speaking about definitions and interpretations under the law. Dr. Nimer Sultany is a reader in public law at SOAS University of London, where he is the chair of the Academic Assembly and the Center for Palestinian Studies. He graduated with a doctorate from Harvard Law School and serves as the editor-in-chief of the Palestinian Yearbook on International Law. Prior to joining SOAS, he practiced human rights law in Palestine and was director of the Political Monitoring Project at Mada al-Carmel, the Arab Center for Applied Social Research. His book, The Law and Revolution, Legitimacy and Constitutionalism After the Arab Spring, won the 2018 Book Prize awarded by the International Society of Public Law and the 2018 Peter Bricks Prize for Outstanding Legal Scholarship awarded by the Society of Legal Scholars. So welcome.
Thank you so much. Good morning. It's such an honor to follow Professor Richard Falk, whose work for decades has been an inspiration to anyone who's interested in speaking truth to power and in critical approaches to international law. And I don't know if this was mentioned in the introduction to Professor Falk's talk. He's also now leading an important effort of naming, which is the Gaza Tribunal, which is in the footsteps of the Russell Tribunal. So thank you, sir, for all your work for justice. Now, I'm going to focus on the question of naming and in legal discourse in particular. Now, obviously, Palestine is a clear case in which the naming of the colonial condition has been for so long delayed, deferred, or even avoided. This lack of naming exposes an uneven application of principles and commitment to human rights. This lack of naming prolongs injustice and delays the application of human rights standards. If we consider the example of the two reports on apartheid by Human Rights Watch and Amnesty International in the 2 years preceding October 2023, we can see clearly that the timing of these two reports is much later than the condition they describe. Factually and legally, most of the analysis and the evidence provided in these two reports was not new. One then must inquire about the politics of human rights and the nature of this delay in naming the condition of apartheid in Palestine. We must also reflect upon and protest the dismissive attitude towards Palestinian and other critical voices who had named the condition long ago and who had analyzed its dynamics and its potential trajectory, but their voices were unheard or even silenced and excluded. We are told that the minimum the role human rights advocacy can play is one of naming and shaming. But where has been the shaming when it comes to Israel? Where has been the naming when it comes to Palestine? A recent example of this delay in naming is a statement by the organization Genocide Watch in December 2024 that stipulated that Israel has committed a genocide. For an organization that is committed to prevention of genocide, the statement came a year late. This lack of naming is, of course, not limited to human rights organizations, but also clear in the case of many journalists, academics, public intellectuals. Despite witnessing Israel's savage onslaught on Gaza for over 15 months, many are still reluctant to acknowledge that this conduct is not symptomatic of armed conflict, but indicative of a genocide. Considering that the Genocide Convention is explicit that genocide can occur during war, this reluctance implies the imposition of a high standard on what counts as genocide to the extent that it would undermine the utility of the Genocide Convention. As the late Judge Trindade warned in his dissenting opinion in the ICJ case of Croatia versus Serbia, the attempts to impose a high threshold for proof of genocide reduce genocide to an almost impossible crime to determine, and the Genocide Convention to an almost dead letter. He continued by cautioning against, quote, a regrettable deconstruction of the Genocide Convention. One cannot characterize a situation as one of armed conflict so as to discard genocide. The two do not exclude each other. Perpetrators of genocide will almost always allege that they were in an armed conflict and their actions were taken pursuant to an ongoing military conflict. Yet genocide may be a means for achieving military objectives just as readily as military conflict may be a means for instigating a genocidal plan, unquote. Judge Trindade's warnings against characterizing a situation as simply war in order to dismiss the charge of genocide are relevant to the context of Palestine because states like the UK indulge Israel's false invocations of armed conflict to cover up a genocide, although they reject this very invocation in the context of Myanmar's genocide of the Rohingya. The continuation of a long-standing armed conflict in Myanmar undermines these attempts. The conflict in Myanmar is often dubbed as the longest civil war in the world, with no less than 35 ceasefires between 1989 and 2013. In fact, in October 2023, Myanmar witnessed a military offensive by 3 armed groups. Of course, the charge of genocide is based on Myanmar's so-called clearance operations against Rohingya. Yet, an examination of the pro-Israeli propaganda reveals that it echoes Myanmar's arguments before the ICJ in 2019. Like Israel's defenders, Myanmar argued that it is complicated. Like Israel, Myanmar uses this invocation of complexity to deny the existence of genocidal intent, that genocidal intent is not the only reasonable inference of from its actions. If Israel proclaims the 7th of October attack as a foundational event, Myanmar refers to the armed attacks by the Arakan Rohingya Salvation Army on the 9th of October, 2016, and the 25th of August, 2017. Like Israel, Myanmar repeatedly argued that this is a situation of tragic armed conflict. Thus, like Israel, Myanmar argued that its conduct in this armed conflict is not governed by international humanitarian law, not by the Genocide Convention. Like some of Israel's defenders, Myanmar criticizes the use, quote, of inflammatory and polarizing, unquote, words like genocide as detrimental to peace. If these arguments are unconvincing in the case of Myanmar, they are even more so in the case of Gaza. In both cases, there are elements of armed conflict. Despite Myanmar's arguments, the ICJ proceeded to grant provisional measures against Myanmar. And 6 Western states, including the UK and Germany, intervened to support the genocide case against Myanmar. Consequently, the attempt to distinguish the cases of Myanmar and Israel is indicative not merely of a high threshold for the determination of what counts as genocide, but of selectivity and partisanship in legal line drawing between war and genocide. Now, one indicator of a genocide in the case of Gaza is that many UN bodies, military experts, and human rights organizations have repeatedly used the word unprecedented to describe the effect of Israel's actions since October 2023. In reviewing some of the primary features of Israel's conduct that generate the descriptor unprecedented, 3 elements stand out. First, the intensity and speed of the aerial bombardment. Within less than a week of the start of its attack on Gaza in October 2023, Israel had dropped on the smaller, densely populated Gaza Strip more explosive than the US dropped on Afghanistan in a year. Within 3 weeks after the start of the attack, Israel dropped the equivalent of 2 nuclear bombs. By June 2024, Israel had dropped over 70,000 tons of explosive on Gaza in less than 8 months, which exceeds by more than twofold the combined number of explosives that both the Germans and Allies dropped in World War II on London, Hamburg, and Dresden. Second, the casualties figures, including the proportion of women and children killed and the rate of killing. By mid-2024, the number of those killed in Gaza already exceeded the number of the Rohingya killed in Myanmar, and the monthly mortality rate in Gaza exceeded the rate in Bosnia in the early 1990s. Third, the comprehensive scope of the destruction that includes non-military targets and makes the Gaza Strip uninhabitable because it deprives the population from objects that are indispensable for their survival as a group. Over 70% of Gaza's infrastructure, from health services to water and sanitation, has been destroyed. Now, within this context of bombing, killing, and destruction, 4 additional considerations further suggest an attempt to annihilate a significant part of the Palestinian people. First, the scale and the pace of the forcible expulsions in October 2023, which, according to the UN Commission of Inquiry in June 2024, was one of the fastest mass displacements in history of a population of 1.1 million north of Wadi Gaza that had no place safe to flee to. Then came the repeated displacements to an area that the ICJ declared in May as unfit for human survival, where the civilians were repeatedly bombed. Second, the imposition of a total siege on the scale and speed of the policy of starvation, which experts labeled as unprecedented. Third, the attack on the so-called last refuge of Rafah, despite the ICJ's third round of provisional measures in May 2024. And finally, the military operation that effectively implemented the so-called General's Plan in North Gaza from October to December 2024, and which was dubbed as ethnic cleansing and a genocide within a genocide. The totality of these actions indicates the commission of genocidal acts and the existence of a genocidal intent that is inferred from these actions and this context, and therefore precludes security and military justifications as credible. Now, naming requires not only naming the genocide itself, but also naming the context in which this genocide has unfolded. The lack of naming that preceded the genocide inhibits a proper naming of the genocide. Organizations like Genocide Watch, which operate within the ideological limits of the Zionist discourse, seek to downplay the genocide even when they name it, such as when they label October 7 as an existential war for Israel, even though several prominent security figures, Israeli security figures like Ehud Barak, have repeatedly rejected this claim and considered it a Netanyahu propaganda. Still, others seek to negate the finding of genocidal intent by reference to Israel's security considerations, but Israel's invocation of security was severely undermined when the ICJ delivered its advisory opinion in July 2024, and therefore provided a much-needed pre-October context. The advisory opinion severely undermines the credibility of Israel's invocation of security and self-defense by insisting on the legal limits of these concepts in the face of a seemingly technical discourse that has justified a colonial occupation and imposed a regime of systematic discrimination as if it were a temporary occupation in response to a military necessity. The ICJ clarified that this Israeli discourse is not credible. First, security cannot justify permanent evacuations or forcible transfer of the Palestinians. Second, security cannot justify a differential treatment of all the Palestinians by imposing restrictions on their freedom of movement to defend the security of Israeli settlers whose presence in the occupied territories is itself illegal. Third, Israel's security concerns cannot justify the annexation of Palestinian territories in violation of the prohibition of the acquisition of territory by force. And four, Self-determination is an inalienable right and cannot be subjected to conditions by the occupier, including on account of its security concerns. In other words, the right to security for one group cannot be at the expense of the total disregard for the rights of another. The combined effect of these arguments is to challenge the logic of Israeli international lawyers who offered permissive interpretations of international humanitarian law that facilitated colonial conquest and creeping annexation. Moreover, some of the separate declarations that the ICJ judges added to the opinion in July highlight the one-sidedness of the security discourse because it justifies Israel's ongoing aggression against the occupied. In particular, Judge Tladi criticizes the amorphous invocation of security concerns, including by some judges in the genocide case. Tladi notes the one-sided and skewed nature of this invocation as if only Israel has security concerns, while the security of the stateless Palestinians is not even factored in. Judge Tladi concludes that security concerns apply to all and cannot override peremptory norms in international law like self-determination. The naming of context is consequential. Judges like Tladi also point out that in the context of the unlawful occupation, Israel cannot invoke self-defense in accordance with Article 51 of the UN Charter, because self-defense does not apply to the Palestinian territories that Israel effectively controls, including Gaza. Judge Charlesworth reminds us that the occupier does not owe the occupier a duty of allegiance or obedience. Similarly, Judge Youssef notes that the illegality of Israel's occupation indicates, quote, an illegitimate continued use of force aimed at creating a perpetual situation of conflict that justify a prolonged occupation. The exception of self-defense to the prohibition of the use of force cannot be allowed to prolong unlawfully a belligerent occupation, unquote. For judges like Youssef and Shaw, Israel's prolonged occupation is in effect a colonial conquest. One limitation of this naming in the ICJ is that it is confined to 1967. But as South Africa pointed out in the genocide case, this colonial conquest and this apartheid started long before 1967. But given the limits of international law, this longer colonial lineage remains unnamed. Despite this, we have witnessed since October that the lack of naming is undermined by the contradictions in Zionist propaganda. This is because this propaganda has reenacted the very colonial discourse that it denies by invoking the distinctions between civilized and barbarians, children of light and children of darkness, and presenting Israel as a defender of Western values, a Western outpost in Asia, which are the hallmarks of colonial discourse. It also moved from the denial of the commission of the crime of the Nakba in 1948 to the threats of committing another Nakba, another genocide. What does it say about Israel and Zionism when it requires the repeated commission of acts of ethnic cleansing and genocide to feel safe? There is an urgent task now to educate against genocide denial under conditions of institutional complicity. And thus, many institutions, including in academia and media, have no interest in acknowledging the genocide because they were its cheerleaders. But once the ICJ issued the first set of provisional measures in January, and thus showed that there is a risk of genocide in Gaza, no excuse was left for those who were silent or reluctant. When the ICJ highlights a situation of a potential genocide unfolding, this generates not only a duty on states to prevent genocide, but also a moral obligation on journalists, academics, intellectuals, and human rights advocates to take the genocide accusation seriously and decry the gravity of Israeli conduct that has generated this situation with the necessary urgency. We need not, of course, wait for pronouncements by mainstream courts to call a spade and to take a clear stance in opposition to mass slaughter and mass destruction, because our moral and political judgment is not reducible to formal legal rulings. When the ICJ on 3 occasions in January, March, and May repeatedly indicated that there is a risk of genocide, and stipulated measures that need to be taken to stop it or to prevent it, then alarmism is justified. It would be a failure to exercise a basic moral duty and a betrayal of basic human values if one decides to stay silent, chooses to delay judgment, or equivocates. By March 2024, ICJ Judge Yusuf told us, quote, "The alarm has now been sounded by the court. All the indicators of genocidal activities are flashing red in Gaza," unquote. Since then, there has been an emerging consensus that Israel's actions violate the prohibition on genocide and a host of other crimes, war crimes and crimes against humanity, because the evidence is overwhelming. With Trump now in power, there's an increasing opposition amongst many who were previously silent to the attack on the international legal institutions and against the criminal plans for the genocidal ethnic cleansing of Gaza. For many, the problem lies in the so-called right-wing populism, or the ascendancy of the far right in many countries. Yet, those who supported, armed, financed, and normalized the genocide in Gaza were the likes of the Green Party in Germany and the Biden Democrats in the US, the Starmers and the Lamies in the UK. Those are not right-wing populists. They must be held accountable. In order to do that, we need to mobilize naming through legal discourse. And when law falls short of the demands of justice, we need to mobilize to bridge the gap between law and justice till such time that Palestine is free from the river to the sea. Thank you.
Thank you very much, Dr. Sultany. I think it's so important to speak about the selectivity, the inequality, and the inconsistency in which the application of recognizing and naming genocide has been applied by both states and organizations alike. But then also what I appreciated was your words about how it's so important to reflect the full context and of the situation and also the full scope of the evidence and information that's available for naming as well. And I think that bridges very nicely into our next speaker's remarks. Professor Neve Gordon is going to be speaking about a specific aspect of analyzing the crime of genocide, and namely the use of human shields. So Professor Gordon, if I can say a few words about him, after teaching 17 years at Ben-Gurion University in Israel, Professor Gordon joined the School of Law at Queen Mary University of London. His research focuses on international humanitarian law, human rights, the ethics of violence, and the Israeli-Palestinian conflict. He is the author of Israel's Occupation of 2008 and co-author of The Human Right to Dominate, published in 2015, and also of Human Shields, A History of People in the Line of Fire, published in 2020. Professor Gordon is the former chair of the British Society of Middle Eastern Studies Committee on Academic Freedom, and he is a fellow of the British Academy of Social Sciences and writes regularly for the Popular Press. So, welcome, Professor Gordon.
So, thank you so much for inviting me. It's really an honor to be here. Before I begin the talk that I prepared, I'd like to say a few things about the law and international law more specifically. States create laws. They create their laws inside the state, and they create the laws and agree upon international laws. And therefore, the law itself is always going to privilege the state and going to be easier for the state to use rather than non-state actors or rather than people that do not have a state. So we have to understand that the law is state-centric and privileges the state. Now, the law also sees things and does not see things. Professor Falk here wrote what I think is the first apartheid report several years before the reports that Nimer mentioned by Amnesty International and Human Rights Watch. I think also analytically, it is the most, it's the sharpest report of all these reports. But the apartheid situation is itself a product of something else. It's a product of the settler colonialism. Why did Richard not write about settler colonialism? Why did Amnesty not write about settler colonialism? Why did Human Rights Watch not write about settler colonialism? Because settler colonialism is not codified as a crime in international law, okay? So we already, at the very start, the problem is beyond the reach of the law, in a sense. The law also looks at events. It has no conception of processes, no conceptions of structures. It looks at the bombing of a building. Now, everyone, as Lara has told us and Haydee before, that this is not something new, what is going on. It's a process. The genocide in Gaza is part of a puzzle. It is not the whole picture. And things have led to that picture. So if you look at the starvation, Israel has controlled the food inside Gaza for years, but the law does not look at that. It's looking at what's going on now, okay? But to understand what's going on now, we need to look at the road to famine. What led us? And the law does not do that. So I want to, before I even begin with my, what I prepared here today, I want to just say that we have to look at the law very carefully, very critically. We have to understand that legal work is interpretation of the law. And interpretation is a site of struggle that often the powerful will win, whether their interpretation is correct or not correct. And so I urge everyone here not to kind of say, oh, the law, because the law will not set us free. The law will not. The law has not liberated any people in history. And if you look just today at what's going on in the United States, how everyone's going to the courts and asking the courts to save them from Trump, the courts will not save them from Trump. That is kind of my introduction to my talk. Now, I'm going to show or to discuss a bit the question of human shields. There's a lot going on with human shields, and there's different aspects of this that are what my argument ultimately will be, that Israel is using the human shielding argument and in a way that it is using the laws that were created post-World War II to stop genocide in order to justify genocide. And that is the danger. And I'm going to try to walk through this slowly. Both the actual use of civilians as human shields and Israel's effort to frame civilian and civilian structures as shields have played a central role in the application and justification of violence in Gaza, at least since 2008. Yet following October 7, 2023, Israel has introduced 3 novel processes related to human shielding. The first involves forcing Palestinian civilians to dress in military uniforms and sending them in underground tunnels as human shields. The second is casting of practically all civilian structures as shielding structures. And the third includes the invocation of shielding provision laid out in the international humanitarian law to indict everyone and everything above ground in Gaza as a legitimate military target. Ultimately, all of these different forms of shielding, and most importantly, the accusations of shielding have become tools of perpetrating genocide and for framing the genocide as legitimate. Before describing these processes, let me say a few words about human shields. The pertinent legal provision states that the use of human shields is a war crime, but also adds that human shields will not render a legitimate military target immune from attack. In other words, it is illegal to use human shields, but it is not always illegal to kill them. Moreover, since it is illegal to utilize human shields, a warring party that kills human shields can assign the blame and legal responsibility for the shield's death on the party using them as shields. The underlying logic here is that the illegal use of civilians as shield put in motion the interaction that led to their death, and that the bullet or bomb that killed them was merely an effect of their original illegal use of human shields, and thus the blame is placed on the original illegal actions. Okay, so if I take Richard Falk and use him as a human shield and you're attacking me, and you kill Richard Falk, God forbid, then ultimately you can blame me for his death because I used him illegally as a human shield. Yeah. When thinking of human shields, Nicola Perugini, my co-author, and I highlighted differences between animate and inanimate shields. Human shields function as a defensive tool, but in a profoundly different way than landmines do to defend a border or anti-aircraft missiles to defend against an airfield. Human beings would seem an unlikely choice of a shield, since as embodied beings made of flesh and blood, they can easily be killed. A human body becomes a shield by virtue of its vulnerability, whereby the vulnerability associated with civilianhood aims to produce moral deterrence on the part of the opponent. Can you move the other slide, please? The distinction between the two types of shields appears in an infographic that the IDF circulated in 2014, and there's scores of infographics like this. Hamas protects its weapons with human shields has been used to lay claim to a civilizational divide between Israelis and Palestinians, the colonizer and the colonized, and to intimate that Palestinian civilians are killed in large numbers because they are used as shields. But the infographic also underscores the distinction between animate and inanimate shields. As opposed to the inanimate shield, which is ultimately conceived and produced in order to protect human vulnerability in war, in the case of human shields, vulnerability itself becomes the means of protection. When faced with vulnerable shields, a certain moral obligation is meant to emerge, and this obligation is meant to dissuade or deter belligerents from attacking a target defended by such shields. It is in this sense that human shielding is fundamentally a politics of vulnerability. I have much more to say about human shieldings, but let's move to Gaza following October 2023. Let's begin with Palestinians, with addressing Palestinian civilians in IDF uniforms. Al Jazeera and Haaretz have reported how Israeli troops abducted Palestinian civilians, dressed them in military uniforms, attached a camera to their body, and sent them into underground tunnels as well as buildings in order to shield Israeli troops from enemy fire. To be sure, Israel's use of shields is not new. However, Palestinians who were used as shields in previous rounds of violence always wore civilian clothes and could thus be identified as civilians. It is precisely the recognition of vulnerability, of civilianhoods, that they are fellow Palestinians, which are key for deterrence to have a chance of working. Israel thus dramatically alters the logic of human shielding. Instead of highlighting the vulnerability of Palestinian civilians, the Israeli military purposely conceals their vulnerability. Israeli troops deploy them as shields not to deter Palestinian fighters from striking the soldiers, but rather to draw fire and thus reveal these fighters' location, allowing the Israeli troops to launch a counterattack and kill the fighters. The treatment of Palestinian civilians in this manner provides a clear indication of the relationship Césaire draws between colonialism and thingification of the colonized. It reveals how the military operationalizes ex-defense minister Yoav Gallant's racist assertion, "We are fighting human animals," exposing how for Israeli soldiers, Palestinians are either prey or bait, animal or bare flesh. Like hunters who use raw material to raw meat to lure animals they want to capture or kill, Israeli troops use Palestinian civilians as if they were bare flesh whose function is to attract the hunter's prey. Palestinian civilians become a thing when they are transformed into bare flesh. But to be transformed into bare flesh, they have already had to undergo a process of racialization that constitutes them as non-human. Such racialization explains why for Israelis, the Palestinian expulsion from humanity appears both deserved and natural. Instead of using Palestinian civilians as human shields, Israel's new practice transforms them into inanimate or bare shields. Before turning to the second difference that we have witnessed in Gaza, the casting of practically all civilian structures as shielding structures, we need to make a brief detour in order to discuss how international law defines legitimate military targets. The law provides protection to civilians and civilian structures where this is not justified by military necessity. The legal protections do not apply where a civilian site is used for military purposes and its destruction offers a warring party a definite military advantage. At such point, the civilian site becomes a military object, which is a broad and fluid term that is difficult to define, but casts that which it names as a legitimate military target. In short, according to international law, any structure that has a military function can be legitimately targeted, while structures that have a civilian function cannot. Yet a structure that has a civilian function can assume a military function, and once this occurs, that structure can legitimately be targeted provided certain principles are taken into account. The law, in other words, recognizes that structures might have a dual use, and when they do, the military function usually trumps the civilian one. How do I make this video work? There's something I can, if you go to the computer, I think you can just press play. Is there? Are people familiar with this? It's a 10-second YouTube clip that the IDF created. This is a model of Shifa. Never mind, let's just leave it back. Model of Shifa, and it showed as if the Hamas Central Command is under Shifa Hospital, okay? And once that is the case, Shifa Hospital becomes this dual-use structure, and then, provided certain conditions, the law allows Israel to attack the hospital, okay? Now, what I want to claim here, the point here is that in the law, what matters is actually not whether it's human or non-human, which we think of often is one of the major distinctions in the world. The major distinction in the law is the functionality between military and civilian. And once something is framed, whether it is or it isn't, but framed or cast as a military site, the law, if you abide by certain conditions, allows you to target it. Okay? And so what basically Israel has done, how much more time do I have, Haydee?
Few minutes.
What is a few?
Five.
5 minutes. Okay, so let me move on. So what we know what Israel has done, if I move to the end and then walk you through it, is Israel has claimed that there are tunnels under the whole Gaza Strip. And therefore, everything above the tunnel can be framed as a shield. Okay? It's shielding the tunnels, whether it's Shifa Hospital, whether it's a school, whether it's a mosque, whatever it is, an apartment building, it can be framed. Now, we don't know exactly where the tunnels are, so potentially the tunnels are everywhere. There's hundreds of kilometers that are set. Now, but we have to understand that to indict so many buildings, so many hospitals, so many schools, so many universities as shielding, the buildings themselves have to be racialized. So you see them as kind of guilty, okay? Now, we often think that people are racialized, but not buildings, not space. But if you look, again, as I said, time is very important. If you look, since 48, what has Israel tried to do? It has tried to Judaize space, to give space and the buildings and the structures on it a race that is Jewish, okay? And if I racialize a building and I racialize it as Palestinian, okay, and we saw about how the racism operates to render even humans as things that can be killed. So once I racialize Shifa Hospital as Palestinians, it becomes more easy to indict it as shielding structure, okay? And so just to get a sense, okay, so let's say there is a Hamas headquarters somewhere around Shifa. The central headquarters of the IDF is in the center of Tel Aviv. In a 1 mile radius from the command center of the IDF, there are 24 schools. If Hamas bombs Tel Aviv and hits these schools, what it could do is what Israel does. It could say the schools are shielding schools. They're shielding the central command of the IDF. But no one would believe them. And that's where race enters. That's where the racism enters. So when Israel says and creates this movie that then turns out to be a fabrication, okay, then we understand that, that racism is everywhere. And so what does the Israel Ministry of Foreign Affairs tells us? The mere fact that seeming civilians or civilian objects have been targeted does not mean that an attack was unlawful. And the critical word here is seeming. The hospitals seem to be hospitals, but they're not hospitals. The schools seem to be schools, but they're not schools. The mosques seem to be mosques, but they're not mosques. The apartments seem to be apartment buildings, but they're all legitimate military targets. Now, if Israel, and with this I'll close, if Israel gets away with this interpretation of the law, And it is an interpretation that exists in the law, okay? It's I think, a flawed interpretation, but it exists. The law gives Israel the arsenal to kind of interpret it that way. But if Israel manages to get away with this interpretation, then we have this crazy situation where the very laws that were created to ensure a never again are used to defend an again. Thank you.
Well, thank you very much, Professor Gordon. I think it's quite a sobering view of the reach of the law, but also how the law is being used, especially this analysis of how the definitions and the analysis of the law is essentially being flipped in order to move from protections to justifications. That's something important to confront and to realize. So now can I turn to Lara Elborno, who's going to speak about obligations under international law, but also about the possibilities and challenges for accountability as well. So if I can introduce Lara. Lara is a Palestinian-American international lawyer and activist based in Paris, though her family originally hails from Gaza and Jaffa. She specializes in international disputes and dedicates a large part of her legal practice to pro bono work, including the representation of asylum seekers in France. She's also a co-host of a weekly English language podcast called Palestine Pod, and has appeared as a commentator on Al Jazeera, TRT World, Double Down News, and George Galloway's Mother of All Talk Shows. So with that, I welcome Lara.
As I was listening to Professor Neve's presentation, which I was just absolutely fascinated by, I also want to remind that Israel also uses animals as shields, dogs. And so I would love to hear from all the animal activists who have been utterly silent during this entire moment. So I want to begin with the permission to narrate, which I think is very important for Palestinians. And if you're a Palestinian, you probably already know the term. And where that takes us initially is to this reality, this notion that Palestinians in Gaza began to narrate their experience as genocide within a day or two of Israel's assault in Gaza in October 2023. It didn't take very long because it became clear for everyone who was paying attention, and certainly the people who were undergoing the violence, that there was something different, something unprecedented about what was going to occur in Gaza this time around. We immediately began to see Palestinians speaking of ibada jima'iyya, right? It means genocide. It's a word I didn't even know, actually, until October 2023, until I was spending hours each day watching the videos and the photos and just listening to what the people were saying. And I kept hearing this word over and over and over again, and I looked it up and it turned out it was genocide. On October 13th, 2023, so exactly a week into Israel's assault on Gaza, the first scholar of genocide and Holocaust studies, who's incidentally also a Jewish Israeli professor, Raz Siegel, published an article clearly stating that Israel was carrying a, quote, textbook case of genocide in Gaza, and noting, again, as of October 13th, that, quote, Israel's genocidal assault on Gaza is quite explicit, open, and unashamed. Perpetrators of genocide usually do not express their intentions so clearly. This was a week in. As days went on, more scholars of genocide, international law, and state crime began to add their names to the chorus of individuals and institutions affirming Israel's actions in Gaza as genocide, until we reach the point where today there is a consensus that Israel is carrying out a genocide in Gaza. There is a consensus. Now, if you watch the mainstream corporate media, or if you watch the US State Department briefings, and you listen to the Biden administration, and you watch Matthew Miller and Vedant Patel, and all of these phony characters, you might think that there was not a consensus. You might think there was like a reasonable debate about what Israel was actually doing in Gaza. But the point I want to make to you is that there is no debate amongst the people who experienced the violence, who were very clear in what they were experiencing. And there's also no debate that I'm aware of, no serious debate amongst the scholars of genocide and state crime and the independent experts whose job it is to study these processes. Okay, so I always say it's not for Piers Morgan to offer his opinion on what genocide is, because he's simply not qualified to have an opinion on the matter. Okay, but what we've seen is that the popular discourse, the public discourse in the global north, has allowed everybody to weigh in as if they deserve to have an opinion. And I submit that the only people whose opinion matters are the Palestinian people who experience the violence on their bodies, on their families, on their communities. And that opinion, having been reaffirmed by the scholars of genocide, of state crime, of Holocaust studies, to me, is that consensus. There is no serious debate here. There are people who want you to believe there's a debate, but that insinuation is being made in bad faith. I also want to put to you that the genocide is ongoing. Okay, it has not ended with the first phase of this, quote, fragile ceasefire. And I believe that the genocide has become automated in a sense. It's become self-executing. And the reason I believe this is because since genocide refers to the infliction of conditions of life calculated to bring about a people's physical destruction in whole or in part, I believe that it's only when those conditions, which were intentionally put into place, cease, and life expectancy rates, for example, which have been halved as a result of Israel's conduct in Gaza for the last 16 months, it's only when those life expectancy rates and the birth rates are restored that we can perhaps begin to envisage a conversation about the end of the genocide, which of course is only the beginning of what needs to be done in order to restore and fulfill Palestinian rights more broadly, but just speaking only about this phase of genocide. So it's still ongoing, and what will need to be done in order to end the genocide, undo the genocide, stop the genocide, far exceeds what has been agreed to in the first phase of the ceasefire, far exceeds what might even be agreed to in the potential second and third phases, which have been discussed, but nothing has been agreed yet. And so that leaves us with a situation where we may see this continue for years before we actually can speak of an end to the genocide. Now, of course, that will depend on us, and I'll come to that in a moment. Another point which I think is important speaks to the obligations that exist under international law with respect to a situation of genocide. By now, you're all experts, I think, in international law, and you have had to become, because unfortunately, it's just the situation that we were confronted with, the daily scenes contrasted with the efforts to explain and justify and defend what was happening, put people, ordinary people, in front of a situation where now they're watching the International Court of Justice oral arguments, in earnest, with interest, to see what's happening and what's going to be said. And they're waiting for the International Criminal Court arrest warrants, which we know were requested, but we're waking up every day to see, is today the day that they're going to be issued? And if they are issued, are any states actually going to comply with their obligations under the Rome Statute to actually enforce them, or are they going to make excuses? right? So on the point of obligations, I think it's important to remember that the convention spells out more than just an obligation not to commit genocide. It's much, much deeper than that. It's an obligation to refrain from genocidal acts, but also an obligation not to be complicit in genocidal acts, an obligation to prevent genocide, right? An obligation to refrain from incitement to genocide, and an obligation as well to punish genocidal acts, incitement, and complicity, and so on. So there's a number of obligations which arise out of the convention. And as my co-panelists have already alluded to, all of these obligations have been violated by Israel and its Western sponsors throughout this current moment. So when we envisage accountability, it's not only about the Israeli soldiers and leaders. Of course they have to be held accountable, but it's about much more than that. International law requires holding accountable the actors who contributed to the Gaza genocide. It means the US. Primarily, the Biden administration must be held accountable for its complicity. Other states that sent weapons and provided intelligence support, like the UK, Germany, must also be held accountable. It means the mainstream media must be held accountable for repeating false atrocity propaganda to manufacture consent for the apocalyptic daily bombardment of sleeping Palestinian families. They must also be held accountable. And there is historical precedent for holding media accountable in situations of genocide, right? And so compare what the obligations are to where we are in order to envisage exactly what type of an accountability gap we're actually dealing with. And so now I want to turn to speaking about and spelling out a little bit more why the accountability gap exists. And Professor Falk already touched on a lot of these points, so I'll try not to be repetitive and just highlight some areas that I think are important. The first is that international law is not self-executing. We know that if the law were followed, this never would have happened. This never should have happened. But it did because of a political consensus amongst governments, not the people, in the global north, in particular the US, to allow Israel to continue. And so we know that law on paper does not determine outcomes. It simply does not. And if you expect law to do that, then you will be sorely disappointed, because that's not how the system works. We also witnessed a culture in the global north of no red lines for Israel. And I say no red lines in quotes because I remember an interview, probably in October 2023, with Lindsey Graham, if I'm not mistaken, an American congressperson. And he was asked, are there any red lines for Israel? He couldn't think of any. And I believe Antony Blinken was also asked this at some point, and he struggled to answer the question. That's simply absurd. Of course there are red lines. International law imposes many red lines on the conduct of a state, whether it's in a situation of armed conflict or to refrain from genocide or to uphold human rights or whatever it may be. There's an entire legal framework of all red lines, right? So this idea that they couldn't even envisage what these red lines would be in discourse with the media, to me also highlights just how deep this gap is and how serious the distortion is by Western governments and also media in terms of propagating this narrative about letting Israel get away with everything. This also explains the culture of Israeli impunity, which explains why we saw Israeli soldiers gleefully publishing to their own social media accounts evidence of them committing international crimes. They never expected to be punished. They were proud of the killing and destruction. They proposed to their fiancés amidst the rubble of our homes, and they filmed themselves as if it was like some sort of like a cute moment. It was very creepy to watch. And, you know, I remember being asked early on about this phenomenon of self-incrimination, essentially, of every soldier publishing on their social media what they were doing in Gaza. And a question was asked to me on Al Jazeera, could this be used in international prosecution of these soldiers at some point in time? And the answer, of course, is yes. The answer, of course, is yes. And here I'll just pivot to the emergence in this moment of organizations like the Hind Rajab Foundation. How many of you have heard of the Hind Rajab Foundation? See, this is amazing. This is like almost the entire room, and this is an organization which emerged in response to the lack of accountability and has made it its mission to download and archive as much of the evidence of crimes as possible and submit it to jurisdictions, whether national or international. I know that, for example, before the ICC, they've submitted evidence of over 1,000 Israeli soldiers being involved in international crimes in Gaza. They're also aggressively pursuing these Israeli soldiers and Israeli leaders before national jurisdictions using the principles of extraterritorial jurisdiction and universal jurisdiction. So what that means is, for example, if there are Israeli soldiers who are dual nationals and they go back to the country of other nationality, the Hind Rajab Foundation knows when they go back, and they'll file a criminal complaint in order to get that state to open an investigation into these mass atrocity crimes that they have participated in, because they have an interest in seeing justice carried out when it concerns crimes committed by their nationals. And so they are trying to pursue this angle, in addition to the universal jurisdiction angle, which is what allows them to pursue Israeli soldiers while they're on vacation, right? And which is what has led to Israel literally evacuating Israeli soldiers from their post-genocide vacations on the fear that they will be held accountable. Now, this hasn't led to any convictions yet or any prosecutions, and I think the road to accountability is going to be very long. But the point is exactly to do this type of organizing, for civil society to organize and insist that genocide is not inevitable, it's not a new normal. We don't accept, we needed to commit a genocide in self-defense as a premise, and that we will continue to make your lives extremely uncomfortable for as long as you live, using all of the tools that we have in international law in order to accomplish that goal. And I think, for example, about Netanyahu with the arrest warrants. Okay, several states have indicated that they will not uphold the warrants. Several states have made some very ambiguous statements which don't really indicate to us what they would do, but you can read between the lines. A couple of states have come out and said, actually, we respect international law and international legal institutions, and we, as members of the Rome, state parties to the Rome Statute, are going to comply with these warrants. So you're warned. If you come here, this is what you may face. What's interesting is that we've seen that Netanyahu now has changed his flight plans, his flight paths, okay? It's a very small win. I'm not trying to say that this is, the beginning of justice in Gaza, but the reality is that there's a fear. There's a fear of accountability. And I think that that's a good thing, because that has the possibility to change outcomes, to change behavior. This is why accountability is so important. The system without accountability lacks total legitimacy, right? And it's only through trying to close that accountability gap that we will lend any legitimacy to the system. And so that is really where you see the role of civil society start to emerge and take form and do the work that some states are not willing to do. Along the lines of civil accountability, I want to tell you about an option that I have proposed that I believe can be used as a potential avenue to bring claims for compensation that, as far as I know, has not been used yet, has not been discussed yet. And it consists in using Israel's bilateral investment treaties to file a claim for damages to investments caused by Israel in the occupied Palestinian territories, under the theory that Israel is in de facto control over the occupied Palestinian territories. And there is support for this theory from cases brought by Ukrainian investors against Russia under the Russia and Ukraine bilateral investment treaty for loss of Ukrainian investments in the Crimea, which was formerly part of Ukraine, but then came under de facto control and eventually annexation by Russia. The only caveat to this tool, which I believe is very powerful in theory because it would allow for a direct claim for compensation to be made against Israel by an investor who has been aggrieved, is that there's admittedly a limited pool of possible claimants, because the only possible claimants that could file a claim are those who have the nationality of one of the states with whom Israel has signed a bilateral investment treaty. Now, we know that Israel has signed 36 bilateral investment treaties which are in force. Most of them are with countries in Eastern Europe or from where Israel actually has a significant immigrant population. So it's not that, they're not typically the countries that we would envisage may have a Palestinian who has that nationality who could then bring that claim. There are, however, some states which I have identified, for example, Cyprus, and even the UAE, who do have bilateral investment treaties with Israel. And if we could identify a Cypriot or an Emirati investor who lost an investment as a result of Israel's conduct in Gaza or in the OPT, it's a possibility for bringing a claim. We've also seen lawsuits in the US trying to close the accountability gap there. There was one case brought by the Center for Constitutional Rights, was dismissed on the basis of political doctrine. So the idea that the court can't look at this question because it's too political. And don't you know it, that doctrine has only ever been used in situations where the court simply does not want to touch, a topic like Palestine, for example. There's another case right now which is pending by Dawn, seeking compliance with the Leahy Law. And what they're asking for in that case is the cessation of military funding from the US to Israel. That case is pending, so we'll see where it goes. We also know that a number of states have joined South Africa's genocide case against Israel before the International Court of Justice, so I think that's a good thing. The point is that efforts are ongoing and will continue for years to come. There is no statute of limitations for atrocity crimes. If these soldiers are 80 years old and accountability happens, 30, 40, 50 years from now, it can still happen. So I want you to have a long-term view of what accountability might look like for this current moment, and not feel hopeless because we're not getting results immediately, because this is a process. Now here I might depress you for just a minute, but please indulge me. I want you to consider that even if every single person who perpetuated the Gaza genocide went to jail, and every Palestinian received compensation for their losses, it still wouldn't be enough to repay the Palestinians for what they endured in the last 16 months, much less the last 76 years. No legal accountability can truly deliver justice. What is the price of your entire family? Try to put a price on it. And I say this knowing that in 16 months, Israel has wiped out entirely 902 Palestinian families from the civil registry, and moreover left only one individual in 1,364 families. And they killed everyone but 2 people in 3,472 families in Gaza. Okay? The point is that there are limits to legal mechanisms, even if they work, keeping in mind that there's also significant hurdles to getting them to work, okay? So I think we have to ask ourselves, what is our goal? And I believe that our goal is to ensure that the genocide ends and can never happen again. Our goal is to dismantle the structure and the processes that fueled the ongoing Nakba and paved the way for the genocide. And that goes to the heart of reckoning with Israel as a settler colonial regime that's been engaged in a project of displacement and replacement for the last 76 years. We cannot envisage the possibility of ending the various forms of colonial violence that are inflicted upon Palestinians if we do not wrestle with this uncomfortable truth for Israel. And I believe one powerful way to support the realization of that process is to call for a total embargo against Israel. The cutting of all relations, no normalcy, right? And not just relations in relation to the occupied West Bank. So for example, we're not gonna allow imports of settlement goods. That's not enough. It has to be a total embargo. And it's not just my opinion. There's a clear legal ruling that we have now that supports this position. That's the ICJ's advisory opinion of July 2024, and some of my panelists have spoken about it. But the key thing to remember about that, I'm not gonna go through the whole thing, I just want you to remember one thing. In that decision, the ICJ, the International Court of Justice, decided that Israel's occupation of Palestinian land in Gaza and in the West Bank is existentially illegal. What does that mean? It means that if all Israeli soldiers did was plant flowers in Gaza, it's still illegal, and they still have to go, okay? So we're not concerned with whether the acts that they're doing themselves are a violation of human rights. It's their mere presence on our land which constitutes a violation of our right to self-determination. And the only thing which they must do is to leave our land unconditionally. There are no more negotiations. Their obligation is to leave our land unconditionally, right? So the reason this decision is powerful is because it's a very strong rebuke to decades of a discourse which said that the only way that Palestinians can achieve freedom is if their occupier agrees to let them have it. And of course, why would their occupier agree? Their occupier has every interest in ensuring that the occupation is not only maintained, but is entrenched and expands. And of course, we've also seen Israel expand its occupation of Arab land in this current moment. Let's not forget Lebanon, let's not forget Syria, right? Okay, so closing remarks. Closing remarks. I think as part of our effort to address the structural injustices, we also have to remember not to limit ourselves and our efforts to the occupied Palestinian territories. We must also build momentum for restoring Palestinian rights in the entire geography where those rights have been denied by Israel since 1948. 80% of Gaza's population who lived, endured, and survived this genocide until now, 80% of them, are Palestinian refugees from the Nakba going back to 1948. They're Nakba survivors or the descendants of Nakba survivors. And they have the right under international law to return to their homes within the Green Line if they choose, and to receive compensation. And it's not or, it's and to receive compensation. Israel has denied them this right for 76 years, but it cannot extinguish that right, although it has tried. You've seen it do that with its efforts to dismantle UNRWA because it thinks that if it dismantles the organization that's responsible, the UN agency that's responsible for assisting Palestinian refugees from the Nakba, that then they can extinguish their rights. That's not how this works. So any serious discussion, in my view, about the future must lay out all of the rights to which Palestinians have been denied. And the only solution is one where those rights are fulfilled unconditionally, and not where external forces decide the fate of Palestinians and continue stealing their resources, like the gas off the coast of Gaza. I have no choice but to believe that the future will not be a colonial one. And I think if you're in this room today, you also probably share that view with me. If we had lost hope, we wouldn't be here, we wouldn't do anything, because hopelessness is debilitating and it drives you to inaction. So I think if we're here, it's because we have some semblance of hope that the future will be better than what has passed. It doesn't mean that it may not get uglier in the short term, but we have to hold on to that belief. So just to wrap up, not only is the future free, but freedom means self-determination. And what that means for Palestinians is that they decide their fate. They decide their future, not Israel, not Donald Trump, not the West, not anyone else. Thank you.
Well, thank you very much, Lara, for very powerful words, but also a message that brings some hope as well. I think it's been a very important discussion on the law and what it's capable of bringing and its challenges as well. I think for me as a lawyer, I often have an instinct to look at the law as a beacon or have as a steadfast remedy, but it's so important in order to strengthen the law and make sure that it truly and meaningfully can be used for accountability and justice and a remedy, that we have these frank discussions about where we are. So we have a little bit of time for some questions. I think we have only about 10 minutes. But there's some microphones around a room that will be brought to you. Perhaps we could take a few questions at once. When the microphone is brought to you, could you please introduce yourself if you have any affiliation as well, and then if the question's directed to a certain speaker. So I see one question here and on this side of the room. Did we have the microphones? Sure. Yes.
My name is Jamil Gursal. I'm a lawyer in London, qualified in London. I'm not Palestinian at all, but as a lawyer, I have obligation to every oppressed people on this world. With your permission, I would like to make a contribution as follows. Genocide has been taking place against the Palestinians for the last 80 years. Genocide only killing people according to the textbooks and the international law. I would like to add the following. Genocide also exists, in my opinion, against intellectuals by subjecting them to prosecution and persecution to shut them up. I am one of these victims myself. I'm English qualified solicitor because of my contribution on social media saying invaders, occupiers, rapists, murderers, and now genociders. On social media, the Solicitors Regulation Authority, following information or report from a group called Gnasha Jew, took me under investigation. I am now currently under investigation. I resigned from this SRA, Solicitors Regulation Authority. I said, I will not recognize you as my governors anymore because I'm not member of your club anymore. I am free man, I'm a criminal defense lawyer. I will not employ any lawyer to defend me. I will defend myself to the end. As we speak, the investigation is still on. In past now, the file has been given to the so-called judge who is going to determine the penalty I will receive, if any. I said I'm not going to recognize anymore. The question I want to ask you, as all of us lawyers, will you accept or kindly contribute to the genocide against intellectuals, especially lawyers who criticize the invasion, occupation of the Zionists?
Thank you. And maybe we could take two more questions. Yeah, is there one here?
Hello, everyone. My name is Sam. I am Palestini from the West Bank. My question is, with all this international law, and we know not many international countries are abide by, which is a joke at the moment, as a British citizen, as we're standing and going on the streets, shouting at Lamy and Starmer of Free Palestine, what can we do to impose the international law? Because we know that Starmer and Lamy are complicit in the genocide. And actually, when Netanyahu stood on a platform and said thank you to Starmer for his support, he actually condemned him in the court. What can I do apart from just shouting at them, because actually they don't listen, I don't care about our individual liberty? Thank you.
Yes, and one more question before we let the panel answer.
Good evening. I'm Bernard Connu, a French engineer, a militant, and good knowledge of the Middle East since 56 years, the whole Middle East, and also recently filmmaker. My question will be to Professor Neve Gordon. We know that Israeli forces identify the location of everybody by their cell phones. So if a militant is sleeping in his own apartment at night, is it a military target? I think this is a question. So.
Okay. All right.
Because they have bombed a lot of, by this process, they have bombed a lot of building because there were one or several persons inside.
I'm going to let the panel go ahead and answer those questions, and we'll see if we have time for any more. Do you want to start with this?
Okay. There's a lot going on in the questions. One, regarding the last question, we have to think of the concept of people's war. The United States became the United States following a people's war. Okay? Most countries became countries following a people's war. What is a people's war? A people's war is a war where the people take part in the war, where the distinction that the laws of war require us to make between civilian and military cannot really hold, okay? And so but you're asking a question, what happens with a fighter that in the day fights and at night goes to sleep at home? So in reality, we know what happened. We know that Israel introduced for the first time, probably in 2021, but now in full use, AI to find targets. And one of the mechanism was called Where's Daddy? And the idea was that the AI will, through probably billions of data points, identify all Hamas fighters and just, and at night bomb their houses. And that's how the large amounts of civilians that Nima was mentioning in the first weeks was exactly targeting what you're saying. And your question is it legal? My claim in my talk is that that is a question of interpretation. I would say it's illegal, and it's very illegal. But what I try to say, and I think I disagree a bit with some of the panelists here, is that we have to really think when we use the law and how to use the law in a very strategic way, because the law can be a tool against us too. Because the law often favors the powerful. And so the question is, how do we get to impose international law through our posters? I think one of the ways that the law works is that it takes away the possibility of collective action. It's the experts, it's the rule of experts, the law, okay? And we cannot, I don't think it's the role of the protesters to ensure the law. I think their role is different. I think all are different. Someone asked me at the beginning, and with this I'll end, what do you think we should do, okay? I think the legal experts have to decide when to use the law and how to use it to advance the Palestinian case. And in certain instances, and as we saw with the ICC and ICJ, we have made advance. I think the role of the non-lawyers is to use their comparative advantage at the workplace, at where they are, and to create stories of resistance. And these stories of resistance might seem as if they do not have any impact. But one day they come together. And we don't know what that day is, but it will come. And suddenly the picture, the resistance becomes this whole picture, and things fall into place. And our role is to look at the situation with all its horror, see that horror, not turn away from it, and continue to resist.
Thank you.
Would anyone else like to weigh in?
Yeah, in terms of, I slightly disagree. So, you know, the question of the rule of law depends on what is the question that you are asking. If the question is, will law set us free? I mean, yeah, of course. Before Trump and before Biden and before Israel existed, the answer is 99% of the time, no. If you are a sober political activist, if you are someone who has a keen analysis of the actual situation in which you operate, you neither idealize the law, nor you dismiss the law and become cynical to the extent that you disregard any role the law can play. As Neve said, now the law can be a tool. The law is not a refuge from politics because the law itself is a site of politics, of political contestation. And yes, it can have asymmetry of power like any other field of social action. This is what the law is, a field of social action. Now, the law has its own idiosyncrasies and technicalities that we lawyers have to deal with, but at bottom, it is a social field of action. Like any other social field of action, you need to do anti-colonial mobilization in this field. Sometimes I feel that there is a schizophrenic attitude amongst many in these kind of popular dismissal views and cynical views of the law on one hand, and on the other hand, admiring Francesca Albanese or Blena Negroli or one of these big names that we all have admired, but they are actors within the legal discourse. This is why you admire Francesca Albanese. And if you dismiss the role of law, you are reifying law. You are thinking of it as something immutable, something coherent, something that doesn't change. It only changes, and it might change only if we mobilize it to do so. And we need to fight this fight, because law is politics by other means. And yes, we need to be strategic. Strategic lawyers do not always use the law because they want to win. Sometimes use the law knowing they are going to lose. Yes. Do you think the Center for Cultural Rights, when they went to the courts in November 2023 against the Biden administration for genocide, were idiots? Do you not think that they knew that they are most likely to lose, but they saw value in litigating and using the law for different benefits that are not necessarily, specifically in the context in which, where politics and the media between October and December when South Africa applied for the International Court of Justice, you couldn't crack the wall of Western wall-to-wall support in the West, neither in the media, neither in politics, nor the academia. What did crack the wall? The ICJ application by South Africa. Whether they win or not, 7 years from now is immaterial. They might lose. Because the ICJ, this is somewhat of a disagreement maybe from what Lara said, when she said there is no debate, etc. Well, the Bosnia case and the way the ICJ treated it is a scandal. And there's like 20 years of scholarship amongst genocide study scholars and legal scholars who are criticizing the ICJ for what they did in Bosnia. And if they rule that Myanmar and Palestine are not cases of genocide, then the Genocide Convention is meaningless. But we know also who are the judges. They are judges, they are human beings, and they are appointed by states. Anyway, this is a fight we have to fight. The critical scholars in the legal tradition are never dismissive of the rule of law entirely. The problem is not, that the law does not have any role. The problem is you should not think that the law is the only or primary vehicle for advancing and upholding your rights, including freedom and justice. It is only one tool, and you need to put it within the context of a political vision. The difficulty in the Palestinian context, obviously, that we don't have a unified Palestinian body politic. We don't have a unified, legitimate will that represents the Palestinian people, whether electorally or in a revolutionary sense, and that might lead to the situation in which any legal mobilization might be ineffective. But the question, slogans like "the master's tools do not dismantle the master's house" are meaningless in concrete context in which the ethical agent, such as the lawyers who acted for South Africa in December, need to decide here and now what to do, knowing that the law might be limited. So we need to ask these questions in particular context and analyze them not in a revisionist history now because the law did not stop the genocide. Demonstrations did not stop the genocide, and yet we continued week after week to go to the demonstrations because we need to act and we need to try. And unlike Neve, I think we should not leave the enforcement of law to states. We need not also reify the state. We are the state. What is the state? The state is composed of us as citizens and of our representatives. And what this genocide and other crises reveal is that we don't live in democracies. Because the majority of public opinion, even in places like Germany, were for the ceasefire for a long time, but because of the so-called constitutional democracies in the West do not reflect electoral opinion, and because the media does not reflect public opinion, we end up in a situation where there is an urgent need to democratize the political system, to democratize the media that is now corporately owned, in order to be able to bridge the gap between the Lammies and the Starmers and the officials or the formal decision-making and the will of the people. And this is one way in which, for the kind of strategic vision, we can bridge the gap between what we think the law requires and the democracy. So an example of this in which the kind of civil society can be mobilized to try to enforce the law is the question of universal jurisdiction, is the question of the Hind Rajab Foundation that Laura mentioned. So yes, enforcement is through activism in civil society, pressure on our electoral representatives, and trying to restructure our political systems in ways that will make them more democratic. Thank you.
Unfortunately, I think we're running short of time and we're going to have to wrap it up, but I do want to offer, if either of you have any responses to these questions before we close. Did you want to say any final remarks?
Well, I think this has been a very stimulating discussion, I would say that. And I would also say that this naming of genocide is a consequence of reclaiming the law, which is extremely important in shaping a progressive understanding of what the law requires. And as several of us have stressed, law has this dual face. It's used by states and powerful interests to oppress, to justify their own exploitative strategic interests. But the people can reclaim the law, and they are trying to do that. Palestinians have tried to do that through the BDS movement that's now 20 years old. And it is assisted by this legitimation process that these international judicial tribunals possess. And it's a struggle, as has also been emphasized, as to who prevails in the field of action as to how the law evolves, and to have it challenged, as it has been in the wake of the failures of international institutions and leading governments to stop the genocide. It has given a great deal of credibility to efforts of this sort that want to reclaim law for the causes of justice. Okay? And to reclaim law for justice is what will make law have a progressive historical influence rather than a regressive one. And that's worth the fight.
I'm just going to say one sentence. We need everything all the time. We need everything all the time. So, just to echo what Nimer was saying.
I know there's a lot of other questions and a lot of other things that you would like to talk about. I invite you to take this over to lunch, please.